may it please
Now afternoon, just barely.
Good afternoon. May it please the court, my name is Ben Sessions. I'm here on behalf of Mr. Whitman. This case is somewhat unusual in the procedural posture. The court has before it the Ammons case, which deals with exactly this issue that is pending before it. So I sort of cheated in preparing for this argument as I watched that argument. So I'd like to.
I wish more people would do that.
Yeah.
Well, before you get into the Ammons
It doesn't mean I'm going to be any better.
There is.
We held to a higher standard.
That is an honest statement right there. I appreciate that. There is one factual difference here from Ammons, and that is that a couple of the tests were consented to and participated in initially, and you don't dispute that the result of that is admissible, right?
That is correct, Your Honor.
Okay.
First, as to the horizontal gaze nystagmus test, in the first phase of that test, that evidence is admissible against Mr. Whitman. And in fact, the state went through in that motion hearing and made a whole big argument about how strong their case was based on those two clues of the horizontal gaze nystagmus test. That's what they told the trial court, was that we have ample probable cause based on the two clues that were observed in the horizontal gaze nystagmus test. So first, that evidence is admissible against him. That evidence is evaluated under the totality of the circumstances test laid out in Olivic for the application of paragraph 16. The second test and the second piece of evidence that is clearly admissible against Mr. Whitman is his submission to a preliminary breath test. He freely and voluntarily submitted that. That's the analysis that we apply there. So those pieces of evidence are admissible against him. Obviously, there are other things in the course of his interaction with the officer that night that we know are also admissible against him. His manner of speaking. He freely and voluntarily exited from the vehicle. You get to look at his manner of standing, his manner of walking, his manner of producing or not producing his license in this case, and just those general observations that you make of him. What's not admissible against him is the refusal to submit to the remainder of the horizontal gaze nystagmus test. And if the state wants to say that he refused any other field sobriety test, typically we see the walk and turn, the one-leg stand test. So that's the piece of evidence that the trial court has said is inadmissible against Mr. Whitman. The court has not excluded the first phase of the horizontal gaze nystagmus test, which is lack of smooth pursuit. So that's what it is. Is that responsive to the question that was there? So in kind of looking at Ammons, the primary debate that was there, and it was almost universal across the panel then at that point in time, was what happens prior to arrest? That was the questioning, that was sort of the hotly debated issue that was there. So first, in looking at whether or not your right not to incriminate yourself attaches prior to arrest, we look to Elliott, that the quotation that we've seen sort of bantered about repeatedly, which is we have specifically applied paragraph 16 to prohibit the state's use of a defendant's incriminating a person by virtue of a defendant's refusal to provide evidence on the roadside. And that is well-founded in our law. Beginning at day, where you had, it was a witness pre-arrest who is compelling a person to put their foot into a footprint, and moving on from there to Evans. And the questioning from the panel previously in Ammons was really sort of centered around what happens if a law enforcement officer walks up to me, I'm walking down the sidewalk, and says, did you shoot this person? Or produce this piece of evidence for me? Or do something, do I have the right at that point in time to say, I just don't want to talk to you?
On a traffic stop.
I just want to
produce your driver's license.
Your Honor, I do believe that is protected under our Georgia self-incrimination clause.
So it would go that far. So basically, get out the car. They can say, I'm not getting out the car, as your client did initially. So they can refuse anything.
They can refuse to produce or do anything that's at the request of a law enforcement officer that requires them to perform an act.
That could include speaking to them. That could include speaking to them.
Not anything that, not an act, it has to be incriminating.
Well, anything that could potentially be incriminating.
Right?
Every DUI case has a police officer saying there's an odor of alcohol coming from their breath.
I can refuse to
So when you ask them what their name is, they can refuse to give it to you.
They can under the self-incrimination clause.
They can
Obviously,
refuse to roll down the window.
I can refuse to roll down the window. I can refuse to perform any act that potentially would be incriminating of me. And I realize, I heard what counsel for for Ammons in the prior case was arguing. There were some concessions that were made with regard to acts that a defendant is being requested by a law enforcement officer. I don't agree with all those. They're not an issue in my case. But I do believe that to the extent that a law enforcement officer asked me to exit from my car and I refuse to do that, you cannot use my refusal against me in a pre-arrest, no warrant situation.
So perhaps it can't support an inference of guilt that you've been drinking, but it could be used as sort of a factual basis for, if there's probable cause to arrest you at that point, and you're refusing even to roll down your window, obstruction, resisting arrest, something like that.
And, Your Honor, candidly, I did not do a sufficient amount of research on whether or not that would be an unconstitutional limitation on my right not to incriminate myself. I have not explored the issue. It's not here.
Well, and there's a big difference between not being compelled to incriminate yourself and not being required to engage in some fashion. Not every engagement is incriminating, and I'm not sure that it's within the unilateral decision of a criminal defendant to decide what is and what isn't incrimination, right?
I agree with you just in the matter of, is that reasonable? But I'm not sure that that's supported under Evans. I believe Evans allows me, as I'm walking down the street, if a law enforcement officer walks up and just wants to engage me in pleasantries, for me to say, I have nothing to say to you, or not even to say I have nothing to say to you, just to turn your back and
What
walk
about if a
away.
law enforcement officer observes you littering and says, let's talk?
Your Honor, any observations that are made of a person that are naturally occurring, we talked about this in the Awad case, where things that are observed not at the request of a law enforcement officer, but anything that is simply observed of a person, you can use against a person. So if I saw, for example, a person drinking a beer, obviously I can use that in the context of the totality of circumstances that would support my DUI arrest and possibly my prosecution.
So I'm an officer, I see you, some common sidewalk, violation, littering, open container, and I try to engage you, and you say, I don't have to talk to you. I don't have to do anything for you. I don't have to give you my license. And I'm trying to make a determination as to how I'm going to handle it as a law enforcement officer. Can your refusal to engage be used in my determination as to whether or not I'm going to place you under arrest for the initial offense?
The refusal to engage with me cannot be used against me later on in my prosecution for that littering. Obviously, you have the evidence. You have a visual observation of the defendant or the suspect at that point in time that could be used against him. But to the extent that he's refusing to talk with us or refusing to give us any other potentially incriminating evidence off of his person, that cannot.
But now, once I've placed you under arrest,
I'm sorry, Your Honor.
once I've now placed you under arrest, I can secure your ID and those sorts of things.
He can, Your Honor.
Under
Yes,
your
sir.
theory of self-incrimination, could you cover your license plate?
I mean, it's a...
Most importantly, the part that has your tag that's expired.
I'm not sure. I don't know the
That's an
answer
act,
to that
isn't it?
question.
I think you'll find the answer needs to be no, you can't cover your license plate.
I mean, how is that not an act? How is that not an act? When you keep it on your car and it's there, you've made an act to make sure your tag is there, so why would that be any different?
So let's say, for example, that I have proactively covered my tag before I get on the road to cover it up from being expired. An officer observes that. That isn't at the request of a law enforcement officer. That doesn't in any way
provide
shape.
reasonable suspicion for something?
It does.
It's a crime,
Yes,
right?
and you
It
have
is.
not done.
And it doesn't in any way implicate, it's not an act that was undertaken at the request of a law enforcement officer. So therefore, it doesn't
So
in any
the
way shape.
the state has compelled you to display a tag on your car, right?
The state conditions it, yes, to lawfully operate.
Well, the state
a
also
motor
says
vehicle.
they condition your ability to drive on consenting to a breathalyzer and a blood test.
And you're the one that actually puts it on the car under our law, or you direct someone.
So where does it end?
It's the contours that, Your Honor, that we were trying to define at the Ammons argument. Obviously, I have thought through sort of the acts in connection with a traffic investigation, a traffic stop, the production of a license. I had candidly not even considered the tag. That would be a contour
look,
that you all can
the
certainly
fact
explore.
of whether a tag or a driver's license might be incidentally, because of a combination of other circumstances, might be incidentally incriminating. They're not evidence of crime in the incrimination sense. Like, when you hand a driver's license to somebody, the handing of the driver's license is not providing evidence of crime, right?
Oh, Your
It's
Honor.
purely evidence of who you are.
But it may if they run the license, right?
so,
I mean,
Your
they
Honor,
run- Yeah, they run
but-
the license and see you're suspended.
Mr. Colvin, I'm sorry. What I was thinking of was in the context of if you're a trial judge presiding over DUIs, you will know that one of the first things that the officer will say is, did the defendant have any difficulty producing his license for you?
Sure.
But the
fumble-
license itself is not the incrimination, it is the fumbling around.
It is the act produced in response to the officer's request to produce your license. So if, for example, I have impairment of my manual dexterity, that's one of the things that they use in to try to determine whether or not a person may be impaired by a substance. They're going to say, did he fumble with his license? And that's going to be that's going to get the ball rolling all from here. That's how these things are built in our trial court. So that absolutely can be an incriminating act.
Mr.
What would be
Sessions,
used
let me
against
give you a hypothetical. As I recall, a seatbelt violation is only citable, correct? That seems to be what I recall.
As soon as I say yes, Your Honor, I'll be wrong on it, so I'm not
If
sure.
the officer sees a seatbelt violation, stops the car, goes up to the car, asks the person to roll down their window so they can produce a license, and by rolling down the window, the officer is going to smell the odor of alcohol about the subject's person, which is what they write in every report. Is that incriminating? And
Rolling,
can they refuse to roll down the window?
you may refuse to roll down the window at your own peril. You will be arrested as a result of failure to sign that citation at that point in time. That's how that will play out ultimately. That officer will say, either you will roll down this window, or I will bust out this window and remove you from this car.
What if the driver rolls it down this much and says, please stick the citation in and I'll sign it? Can he force him to roll it down further?
Whether or not he can force him to do it and whether or not it can be introduced against him is two completely separate issues. And what I mean by that, Your Honor, is this. He can, in the context of that investigation, he can say, you will roll down this window now. And a person may actually roll it down. But that doesn't mean necessarily that you can use the evidence that's derived in response to that command against a person at trial. Does that make sense?
Why is the license incriminating unless you're looking for a specific person?
So the license is
Like if I were on a manhunt for Joe Smith and I roll down the window and say, give me your license, I'm looking for Joe Smith, and you are Joe Smith and you hand over the license, then I can see why that's incriminating. Why is merely giving a license incriminating?
the way that it's used in DUI cases in particular is that they look for, if you have difficulty producing your license from your wallet.
Right. Well, I thought that was a fair point you made, but I guess what I'm trying to figure out is asking someone to give the license for a safety purpose or just an informational purpose. I don't know why that itself is incriminating. Putting aside that they may be able to observe certain things if someone says, yes, I will. And I'm not sure how the person who wants to refuse would know that it was going to be self-incriminating if they're not a fugitive and they know that, they're being sought by the police.
But what about the fact when they turn over the license, typically, they would run the license because that's typical. They run the license and then they see you have a suspended license. So you've been compelled or asked to give over that license and they run it and boom, there you are. There's a basis for arresting you at that point.
That is, and you have also obviously produced the information that will later be used.
But the evidence of the
incriminate.
driver's license is not generated by the affirmative act. It's simply a document that the state requires you to have if you're going to operate a car and the state simply wants to take that document from you. I mean, we've got two lines of cases here, right? And the line is pretty clear. If the evidence that the state wants to use against you at trial is generated by an affirmative act, you can't be compelled to do that. But if the state can just take the evidence from you, the state can do that all day long.
Yes.
Why isn't that the driver's license and the car tag?
I mean, we do have these lines of case, I mean, we're very familiar with this demarcation, and certainly what we've done is, in a WAD, that was a naturally occurring thing. That was the question, or what that case ultimately turned on, was whether or not the defendant produced it in response to a law enforcement request or demand. And that's what's happening in the license context. You're producing evidence, your license, in response to a law enforcement demand.
That's pretty different. I mean, urinating in a cup upon direction is not the natural way that most people urinate. That they were asked, that person was asked to do something sort of special and affirmative in a way that would generate evidence. I mean, you could put your driver's license on your window so that you didn't have to reach into your
Your Honor,
wallet.
I want to be completely clear here. We're not dealing with refusal to produce. I'm not challenging the constitutionality of the license production statute. We're dealing with evidence that clearly implicates, in this case, paragraph 16 and the incriminating aspects of it. So I certainly, there may be a day where I'm here back before Your Honor challenging the production of a license.
I wouldn't recommend it.
Today is not that day. I am here about evidence that clearly implicates our paragraph 16 case law insofar as it requires overt acts from the defendant. The state has, for all practical purposes, conceded that in its brief. And I would point the court to page 43 of the appellant's brief. It says, admittedly, the horizontal gaze nystagmus test does require some degree of participation by the subject to observe these clues. That is what the trooper can testify consistent with at the motion hearing. It was at pages 21 through 23 of the motions hearing transcript. The officer said without the active participation of the defendant in these tests, this evidence, these clues cannot be observed in him. That is exactly the hallmark of paragraph 16 of our Georgia Constitution, is does it require active participation of a defendant to do it? And we know, setting aside all the debates about tags and license and those things, we know that this is evidence that it tends to incriminate him, and we know that that's the position that the state has taken. Whether or not that can be used against him is controlled by Elliott, is controlled by Day, it is controlled by Evans, it is controlled by, directly on point, Aldridge. And Aldridge obviously deals with, it's an interesting analogy as I was going back through in my mind, going back through the license question and the production of your license and your tag, the Aldridge case and kind of the interplay there, but I hope that we never get to that point. Any other questions for me?
Can I ask you, now that you're done, can I ask you the same question? The implied consent statute and the structure, what is the basis for the determination that the Court of Appeals seems to have made, and most people seem to accept, that the officer has the right to designate what substance, clear that he can designate what test will be used, but what substance will be tested?
That authority, to my knowledge, comes from 40-5-67.1. Where the implied consent notices are, there is the parentheses that's in each of the cards that says officer shall designate.
Designate test here.
Yes, sir. Yeah, that's where I believe that procedure, that process, and obviously we've got those Court of Appeals cases that deal with that.
Are they right? I'm saying, in a matter of statutory interpretation, are they correct?
I was trying to save my implied consent issues. That's kind of a hold it back for an appeal if things went awry for me at trial. So
That's called sandbagging.
that was what my hope was anyways. Hopefully I don't get there, so I appreciate y'all. Thank you.
Thank you, counsel. Ms. Murphy, you've got 21 seconds.
I'm glad that Mr. Sessions mentioned the Aldridge case, because the Aldridge case to me makes my point very clear. Because the Aldridge case actually does not deal with the use of the refusal in the trial on the violation of the weight restriction. It's actually an appeal of the conviction of the crime of refusing. And that shows very clearly that the compulsion is the key factor.
Thank you, counsel. Thank you, both of you, for fine arguments. We'll get you a decision as soon as possible. We'll be adjourned until tomorrow morning's session.